file briefs and set it for oral argument. So that'll be completely up to them as to how they want to handle it. They could act on Judge May's findings, or they could decide they want to hear from the lawyers one more time, give us another opportunity to brief the case, and have a little input into the decision.
What do you make of Judge May's recommendation?
It looks like he worked extremely hard in researching the law, researching the facts, researching the medical basis for the testimony. I have nothing but great respect for the effort that Judge May's put into trying to reach a decision in this case that he's comfortable with. And, you know, we regret that he didn't agree with us, but I certainly can't complain about all the effort that he put into his decision.
What's going to be your strategy now from this point on?
We're going to have to determine whether we need to file any kind of objections to the judge's recommendation to the Court of Criminal Appeals. And the case will go up to Austin, and they will decide whether they want to grant relief based on the judge's recommendation or whether they want to ask for briefs and set it for oral argument.
If the Court of Criminal Appeals agrees with the trial judge, that means the choice for the county is he's either free or you retry him, right?
Yeah, the outcome would be that it be remanded to Montgomery County for a new trial, and then we would have to take a real close look at this case, obviously, to determine whether it's something we want to try again or whether we're done.
Gotcha. Does the Norton's change of opinion affect? That would seriously affect that decision, wouldn't it?
Well, at the time that county authorities retained Dr. Norton, we had a great deal of respect for her experience and qualifications, and she worked very hard on the case, and we thought that her conclusions that this was a homicide resulting from suffocation were medically sound and well supported. We're very sorry that we weren't able to obtain her deposition. We know that at least one pathologist out there thinks this was a homicide. One of the things we would have to explore if we're talking about whether or not to have a new trial is whether we could present medical evidence that establishes it's a homicide. I don't know if that's available or not at this point.
What was the other evidence against him indicating that he had harmed the child previous to this?
There was trial testimony in the original trial that the child had turned up injured on 3 occasions while left in his care. And Robbins testified at trial that he had not intentionally harmed the child, that it was a result of his carelessness. But the state had argued at the time that was some evidence that supported the belief that it was a homicide case.
What kind of injuries, do you know?
Bruises,
bumps
primarily bruises and an injury to the leg that prevented the child from standing or walking for about 4 days.
Oh.
So 3 times, I mean, that one would say that shows a pattern right there.
That's what we argued at trial, and that's what we would argue if the case gets retried, yes.
Great. Bill, how do you spell your last name? 1 L?
It's Delmore, D-E-L-M-O-R-E.
Right.
Bill Delmore.
Yeah.
So, if my understanding is correct, you can appeal this recommendation.
Well,
No, the recommendation, Judge May's recommendation goes to the Court of Criminal Appeals, and they make the ultimate decision. They can hear from us, or they can decide they've heard enough.
Okay.
That's going to be their choice as to how they want to handle it in Austin.
Gotcha.
prosecution have right of appeal if they affirm that you don't have right of appeal of that. Do you?
No, because the Court of Criminal Appeals is the final decision in
Right,
criminal
that's what I thought.
cases, so that would be that.
Thank you very much.
Yeah,
Appreciate
good to
it.
see you.
Thanks.